Today we're going to have a look at the Karen Reed civil case, and I'm going to explain to you what's really going on. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. When you hear that Karen Reed has been sued for wrongful death, naturally you think that that's the basis for the lawsuit, that they're really going after Karen Reed, who doesn't really have any assets left after having been drugged through the criminal case by this cabal of people. So now you have to wonder, why in the world would a plaintiff's attorney, even a guy who's just in his own law office, a guy by the name of Mark Diller, I believe, why would he do that? Why would he take on a case to win a Pyrrhic victory? Because even if he got a $10 gazillion judgment against Karen Reed, there's no assets to fulfill it. So that raises another question. What could possibly be the rationale for that lawsuit? Well, I'm going to show you the lawsuit, and then I'm going to explain what's really going on. So let's take a look at the lawsuit that's been filed. First, let's look at the pleading from the law firm here that details what they're after. It's Paul O'Keefe as the personal representative of the estate of John O'Keefe III, Paul O'Keefe individually, John O'Keefe II, Margaret O'Keefe, and Margaret O'Keefe as grandparent guardian of Kaylee Furbush. Those are the plaintiffs. Versus, wait a minute, I thought we were going after Karen Reed. CNC Hospitality LLC, doing business as C.F. McCarthys, GNF's Hospitality LLC, doing business as C.F. McCarthys. Well, which one is it? Waterfall Bar and Grill Limited, doing business as Waterfall Bar and Grill, and Karen Reed. Well, wait a minute. She's the last person named? Yeah, because this lawsuit is not aimed really at Karen Reed. It's because they know she doesn't have a fund of money to pay this. This is aimed at the deep pockets of the two bars where the couple went to the night of John O'Keefe's untimely demise. And they've set themselves up for having a real problem in proving all of the elements of their claims. But I think it's interesting to take a look at who the parties are and what their claims are. So the first little bit of this talks about who the plaintiff is, and John O'Keefe is the surviving father, and Margaret O'Keefe is the surviving mother, and Kaylee Furbush is the surviving niece. And at all relevant times, defendants, and they list them, they were doing business as these two bars. The defendant, Waterfall Bar and Grill, is a domestic corporation, which means that it was incorporated in Massachusetts with its usual place of business and registered agent, all that. That tells the people in the courthouse where to serve the documents on the company. The defendant is an individual residing at 481 Gilbert Street, Mansfield, Bristol County, Massachusetts. So that's pretty interesting. Now the facts. Plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety all prior paragraphs of the complaint. This is something that lawyers do that they really don't need to do, because although all of those things are facts, they're important to jurisdiction and to getting the right people served, but they're not really that important to the actual claims. But it's always been done that way, and I'm sure in Massachusetts it's always been done this way, so they do it this way. The decedent, J.J., was the middle of three children in a tight-knit family. J.J. was a third-generation Boston police officer. After the tragic death of J.J.'s sister, Kristen, and brother-in-law, Steve, J.J. took custody/guardianship of his niece, Kaylee, and nephew, Patrick, who were 6 and 3, respectively. Over the next 8 years until his tragic passing, J.J. raised and supported his niece and nephew. Okay, I think we all knew that. This is a way to get to the financial loss of all of these parties. And it also puts a human face on the plaintiffs here. You know, they're aggrieved individuals who lost somebody important to them. And it goes through the months leading to Karen Reed and all of that. And then on the night of January 28th, they arrived at CF McCarthys. It's licensed to distribute, sell, or serve alcohol on June 28th, 2022 at about 8:58. McCarthy served Reed an alcoholic beverage. Reed consumed said drink. Now, what they're setting up here, and of course they had to do this before they did this in August of 2024, so they didn't know what the outcome of the criminal trial would be. So, what they're laying out here is all of the drinks that were served to Karen Reed, irrespective of the witnesses who said, look, she was doing just fine. She wasn't noticeably impaired. But this is where Karen Reed has a bit of a problem. She has been convicted of driving drunk or operating a vehicle under the influence. And as a result, she is not going to be able to deny that she was drunk. This is essentially a dram shop case. And a dram shop case is a case that's brought against a bar or an establishment that serves alcohol. So it could be a restaurant. As long as it serves alcohol, you can bring a lawsuit against them if they overserve a patron and that patron harms someone else or even harms themselves. So that's what's at the bottom of this particular lawsuit right here. It's a Dram Shop Act, and they're going after C.F. McCarthy's. So they go through all of the times that she had a drink at C.F. McCarthy's, and then they go over to the Waterfall and all of the times that she had Waterfall alcoholic beverages. She consumed the drinks, and then she was under the influence and unable to drive a motor vehicle safely. Well, that fact is certainly open to dispute. She certainly had been convicted of that, but the safety of her driving has actually been attested to by people who testified in the criminal trial. So there's that part of this. Uh, they said they'd been in a fight, and then at all relevant times, defendant drove her SUV in a state of intoxication. As a result, SUV hit John O'Keefe. John was knocked down onto the ground in front of 34 Fairview, suffered serious injury, and died. After hitting her, JJ returned to the scene, fled the scene, and returned to her residence, or JJ's residence. At all relevant times, the defendant knew that it was snowing, knew there was an impending blizzard, knew that it should have known that JJ was outside, and the blizzard would likely result in serious injury or death. Well, which is it? You know, either she hit him and he suffered a brain injury as a result of being hit, or he died from hypothermia because he laid out there in the snow. It can't be both. And although hypothermia was mentioned in the autopsy result, the fact is there's a lot of competing information in the other forensic evidence that was introduced at trial that says he wasn't really hypothermic. So these are the allegations of negligence. Now, the reason that they are alleging negligence and not an intentional vehicular assault is because if Karen Reed did have car insurance, and if it's not invalidated by the fact that she drove in an intoxicated state, then they can recover on the negligence. They can't recover for an intentional act because every car insurance policy has an intentional acts exclusion. So you go on down, and then she was reckless at all times. She woke up, and this is something we certainly didn't hear at trial, and so I question the veracity of it. But she talked to the 14-year-old niece and told her that she had hit John. We don't have Kaylee Furbush's testimony from the trial because it wasn't video recorded because she was a minor. And as a result of that, we have to rely on partial transcriptions that come to us through court TV. But at trial, she didn't say that Karen Reed said she hit him. She said, maybe I hit him, because She was frantic. That was the description that she used. And she also said that Jen McCabe was level-headed. Well, if this man is her friend and he's missing, you would think that she wouldn't be level-headed. She'd be frantic too, trying to find her friend. But of course, I think Jen McCabe already knew where John O'Keefe was. So Furbush's testimony in the criminal trial doesn't really support the allegations that are in this complaint. But at any rate, that's what they're going through. They're laying out all of this with regard to Karen Reed because it's absolutely crucial to their case against the other two people who have deep pockets. So they lay out all of this, and then they say that her blood alcohol content was between 0.13 and 0.29. Again, that is entirely speculation. They don't have any evidence of that fact. They can't pin really what the BAC was. But again, that doesn't matter as much with regard to Karen's liability because she does admit and was convicted of driving under the influence. So she is collaterally estopped. She can't deny that because the jury found that to be a fact in her criminal case. And then the main thing that she can deny, of course, is that she hit John O'Keefe. And that's where the evidence all stacks up on her side. And that's where it makes it very hard for the plaintiffs here to recover against both Reed and these other two institutions. So count one is against C.F. McCarthys for wrongful death under the Dram Shop Act. And that's a statute in Massachusetts that allows somebody to sue on behalf of a decedent if they've been injured as a result of the overconsumption of alcohol. Now, here's where it really gets, well, I'll put it this way. Generally speaking, in Dram Shop Act cases, you have to have knowledge that the person is way over the limit and that they're going to drive or in some way hurt somebody else before you can be liable for over-serving them, because a bartender is not charged with the responsibility of breathalyzing each person before he serves them another drink. That's just not reasonable. But you certainly can tell in many instances when someone is over the limit and you don't serve them. If they're slurring their speech, if their eyes are glassy, if they can't focus on you, if they just pound on the table and say, I don't have another drink, then, you probably shouldn't serve them that alcohol because they might be stupid enough to go out and hurt somebody. All of the reports from inside the bar that night say that she wasn't acting as if she was, intoxicated. I guess perhaps Jennifer McCabe and maybe the other people in the McAlbert group might very well testify that she was blitzed beyond measure, could barely stand up, but the video doesn't show that. And that, I think, is the key part of where you're going with this. If you're going to charge this facility with over-serving, you've got to prove the over-serving, plus you have to prove that she hit him with her car. And again, the evidence doesn't stack up, and more importantly, they're not going to have the same judge. And so a lot of the things that were excluded by Judge Cannone may very well be admitted in this civil trial because the rules are different and the standards are different. So they've got a pretty long haul, but this is essentially what they're after. They are after, in most respects, a judgment against these two bars. So they talk about what C.F. McCarthys did wrong. It's a negligence claim. And then it's against Waterfall Bar and Grill for the same thing, Dram Shop Act. And then it's the estate for wrongful death versus Karen Reed. Again, they have to have this in order to proceed against the other two institutions. But to me, it doesn't look like this is the primary focus. If this were the primary focus, Reed would only be the defendant that they had, and the other two would be thrown in as sort of afterthoughts. How you structure your complaint, where you put the the big claims at the front, that tells you a little bit about who they're really going after here. They're really going after these two bars. And then what happens when they're done? Then they go after McCarthys for negligent infliction of emotional distress, and they go after McCarthys for negligent infliction of emotional distress for John O'Keefe, and then they go after it for Paul O'Keefe, and then for Waterfall for the same things, and Paul O'Keefe for the same things, and then Margaret O'Keefe gets negligent and or reckless infliction of emotional distress. So you got 10 counts at this point, and all of these are what we call pleaded in the alternative. In other words, you're not going to get a recovery on all of these things. You're going to get one wrongful death recovery. These are just 10 different theories on how you're going to get that recovery. And then count 11, negligent and or reckless infliction of emotional distress. Negligent or reckless infliction of emotional distress. Count 13, negligent or reckless infliction. And these are all fairly standard claims that you might make in a case, but you have to have the facts to back them up. And again, I don't think they have the sufficient facts to actually recover in a civil case here for a couple of reasons. The first reason is that they don't have any broken bones, they don't have any bruising. There are the animal bites on the arm, the animal and claw marks on the arm, all of these things. The fact that the taillight pieces were found not in the road where they would have been, but over by where John was, or supposedly was at the time, that to me sort of telegraphs this whole idea that they really did set up Karen Reed. But in this situation, the civil situation, they have to prove that she hit him. And the fact that the state did not prove that to a beyond a reasonable doubt standard, and they now only have to prove it to a more likely than not likely, that lowers their burden somewhat, but still, they have to explain why there's no broken bones. They have to explain how he was found up in the yard and there were no tire tracks there. They have to explain why the taillights were found up in the yard, but there were no tire marks there. They have to explain all of that, and there is if the defense can confuse them enough, then I think you've got a pretty fair chance at avoiding any kind of a recovery for wrongful death here. Now, here's the really interesting thing. The lawyers who are going to be fighting this lawsuit the hardest have to fight for Karen Reed too, because if the plaintiffs establish that Karen Reed actually did hit him with the SUV to this lower standard, then there's a valid claim perhaps against these two bars. But again, they have to prove that there was knowledge, that they knew she was being overserved, and they served her anyway. And that, I think, creates a real problem. Now, the Dram Shop Act in Massachusetts is really pretty simple. It basically says, in no uncertain terms, nobody who's licensed to serve alcohol in the state or in the Commonwealth can serve someone who is intoxicated. And the regulations under that law require bartenders and servers to look for signs of intoxication, slurred speech, glassy eyes, all of that kind of thing. So, in some respects, they may very well have some claim that they didn't do that. I think you put the waitresses and the bartenders who served these drinks up on the stand and you say, did you look at this? Did you try to figure out if these people were intoxicated? They'd been to a different bar. Did you not realize that maybe they'd been kicked out of that bar because they had been overserved there? Why did you continue to serve them? So Waterfall may have more than C.F. McCarthys in terms of liability. But the fact of the matter is, if they did not actually figure out whether these folks had been overserved or not, that could occasion liability. But again, it is only if the jury finds that she hit him. And of course, that does not seem to be the general belief of most of the people, well, certainly not the people who are protesting outside the courthouse. Now, I don't think you'll see that kind of thing in Plymouth, which is where this case is going to be venued. I don't think you'll see that kind of interest in that case, but you might. And if you do, I don't know that it would have any impact on the jury. If I'm on that jury, it doesn't have any impact on me. If I'm on the jury, I want to know absolute proof that she hit him, and I want somebody to be able to explain to me how she could hit him such that he had a brain injury, but not a broken arm, not a broken hip, not a broken leg, no bruising anywhere, and dog bites. I have to know that before I could vote to say she's liable under either the Dram Shop Act or the wrongful death law. And by the way, I went back and looked at 28 or MGL section or chapter 229 section 2. That's actually the wrongful death statute. It's not the Dram Shop Act. The Dram Shop Act is chapter 138 section 69. And again, it's a very short one paragraph statute that says don't serve anybody who's already intoxicated. So that's sort of the basis of what's going on with Karen Reed's lawsuit. And I think it probably has more to do with them wanting to get money from these bars than it does with them wanting to get money from Karen Reed, because clearly Karen Reed does not have the resources to pay off a judgment at this point. And like I said, she's going to get lots of help from these bars because they definitely do not want to have any kind of liability as a result. So one of the things that will happen when they put Karen Reed up on the stand, because she cannot take the Fifth Amendment now, she's been cleared of any liability associated with the crime, with the criminal acts. She's already been cleared of that, other than the DUI. They're going to have to put her up on the stand, and she's going to get to tell her story. And when the plaintiff goes through that, has to ask, open-ended questions. The defense is going to examine her with leading questions, saying, you weren't drunk that night, correct? You didn't feel like you were drunk, right? Yeah. You were driving okay, yes. You didn't speed, correct? No. You turned lawfully, yes. You were very cognizant of your driving, correct? Yes. And you didn't hit him, right? Yes, I know exactly that I didn't hit him. I'm sure there'll be some drama in that case. I doubt very seriously if that civil trial will be streamed or televised. I think it would really be good if they did do that, but I don't see that happening. Anyway, I thought you'd be interested in that. Thanks for watching. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.